Quintilian?
Yes. May it please the Court, good morning. I represent the defendant, Robert Cabrera. This case arises out of a breaking and entering that occurred back in 1998, and the crux of the appellate issues that I raised in my opening brief has the basic philosophical premise that the convictions for receiving stolen property and also for a B&E with the intent to commit a larceny are legally inconsistent. And
how can that be when they're two different crimes? The receiving is one thing, but independently you've got a breaking and entering, which has nothing to do with the larceny or the receiving.
Well, with the breaking and entering, it's a breaking. By definition, the crime is breaking and entering with a specific intent to commit a felony. In this particular case, the Commonwealth alleged in its indictment the specific intent to commit a larceny on the specific day with regard to Bernie's. And the indictment is in the record appendix on 7.
As a factual matter, as I recall the facts, almost $80,000 worth of property was taken from this store, right?
Correct.
And when the defendant was stopped by the police, he had some items, there were some items in the trunk of the car, but they didn't represent $80,000 worth of goods, did they?
Well, not in that initial.
So when he admitted to receiving stolen goods, he wasn't admitting to receiving stolen goods of the $80,000 worth of goods, was he?
Well, that is a very good question, and the record is ambiguous with that. We are limited to what is in the record below. Now, unfortunately, his colloquy, when he pled guilty to receiving stolen goods, that tape is no longer available, so we are now restricted to the record below. And what's in the record below is 2 police officers who testified that they were in court during the colloquy, and the only evidence in the record is that he pled guilty to receiving stolen items, they didn't list them, that occurred on the specific date of the breaking and entering that comprises both of these convictions. So
was the breaking and entering the same day as he was arrested?
No, he was arrested, I believe, 3 or 4 days after the B&E. But specifically what's in the record is that both police officers who were in that courtroom on that day specifically said, in response to the prosecutor's question, were those the items that were taken on the break that occurred in this case? And both police officers said that, and I could direct the court's attention to that, specifically with both police officers. And also there's testimony in the record regarding the manager of the Bernie stores, and he also specifically testified that the items that were recovered, that he recovered when the defendant admitted during the plea colloquy, he also stated that all those items were the items that were taken on the day in question. And if I could direct your attention to...
Wait, are you saying that it was stipulated that all the items that the defendant was found with at the first arrest were all the items that he was charged with in the second arrest?
Well, it's ambiguous. The record is ambiguous.
That's what I thought you said,
Yeah.
but then I thought earlier, but then I thought you
But-
just said that it was stipulated.
Well, no, not stipulated. Well, we have testimony of 2 police officers, and we have testimony of the manager of the Bernie store. So we have, and that's only, there's no stipulation with regard, but they are responses to the prosecutor's questions regarding the merchandise that was taken from Bernie's.
Well, he was charged with receiving stolen goods valued over $250, wasn't it?
Correct.
So,
Correct.
And the merchandise that was taken was DVDs, video camcorders, pagers, movies, radios, VCRs, and other electronic devices. And
Yes. There's testimony in the record from the other defendant that had indicated all those merchandise.
Okay, and what was
taken.
when he was charged with the receiving, did it include all the items that Justice Ireland just listed?
Well, it would have been helpful to have the transcript of the colloquy. Unfortunately, by the time this case came around, it's no longer available, so we're restricted to what's in the record below.
It's unlikely, though, surely, that there would have been a complete listing of all of the items.
Again, I would agree with that. However, the question is that in the record below, it basically has the testimony of the police officers saying, yes, that's the merchandise that was taken from Bernie's on that same day. I suspect from my experience that they wouldn't have gone through each and every item with regard to that during the plea colloquy, but I don't have the transcript.
Do we have any appellate decision that says that you cannot, that it is duplicative to be convicted of breaking and entering with the intent to commit larceny and larceny?
The closest case that exists, Judge, is the case of
The larceny and the receiving stolen property.
it was no, it was burglary and larceny. That's the closest case that we have, and I cited that case in my brief, and it's the case is Larned versus Commonwealth at 53 Mass 240. And that was decided in 1847, but that's the closest. We don't have an identical case.
And that says that you cannot be convicted of larceny and the crime of burglary.
Yes, with intent to commit larceny, correct. That's the closest we have. The only recent cases...
But we don't have larceny here. Here we have receiving stolen property.
well, correct.
Well, let me ask you this question. Suppose that the defendant breaks... What if he were interrupted in a B&E? B&E with intent, and he's charged with B&E with intent because he gets in, but he never, and with the intent, but he never succeeds.
Correct.
But his accomplice went in another door and succeeded, went in the back door. And then the accomplice transfers the goods to the defendant. Couldn't the defendant then be charged with B&E with intent to commit larceny and also with receiving stolen property? He would have done both.
Because you're separating it into two separate acts.
Well, he tried to get in, and he got in, and he had the intent to commit larceny. He had burglarious tools on him and whatever, and a box to take the goods away. But he was somehow thwarted once he got inside, and he ran out. But his friend got in the other door and came out and gave him some of the goods, which he put in his box and walked off with.
And my answer to that is that they're legally inconsistent because what it presumes is that you're receiving, somebody has to, you can't take an item and give it to yourself. You know, so
but he didn't in the hypothetical I just said. His friend went in the other door, got in. He was scared off because he saw an alarm. He went out. But and his friend comes out and later that day gives him some of the goods.
I guess in that hypothetical that it would be distinct, separate
So
crimes.
they aren't necessarily inconsistent, duplicitous.
And it would depend on the facts of the situation.
So here it's very important that we know whether the goods were the same ones in both instances.
Correct, and they are.
It's key.
And can we go back to the facts for a moment? I just have a note here that when the police did the search of the trunk of the car, they found a bag containing 37 electronic pagers in the trunk. You agree with that?
Yes, I do.
Now, do we know whether more than 37 pagers were stolen from...
See, now the record below is a little fuzzy on that because the only person who would have that information was the manager of the Bernie store. And the testimony is he didn't go through and say this was stolen. What they did is they just admitted a listing of items or inventory. They didn't go through and say which ones were stolen and which ones weren't. So the record's fuzzy on that in terms of you know, well, we had 500 items of this, and we only recovered 100.
Can I ask you a question? Well, you weren't trial counsel.
No.
Why isn't this waived? There was no pretrial motion or any motion at all at the trial asserting any double jeopardy grounds.
And you know, Judge, that's a good question. If I was trying it, I would have done a motion to dismiss. But with regard to the waiver issue, I would submit that the case law isn't very clear on that in terms of whether, in fact, you need to bring a motion to dismiss. And the case actually was decided by this court in May of 2007. And basically, in a footnote, you said that the case law is not quite clear on it. And if I can give you the cite.
Well, so how do you preserve the issue for appeal? Even if it's not clear, how do you preserve the issue for appeal?
My argument would be, Judge, is that he raised the issue in his motion for required finding. And he raised that issue and said, look, these two convictions or these two crimes are legally inconsistent. Actually, he was pretty good about, throughout the whole trial, really raising this issue.
But was there evidence at the first trial that he had been previously convicted of the other offense?
Evidence that, well, of
the earlier offense?
Guilty.
Yes. There was a lot of evidence that came in that he pled guilty to receiving the same goods that came out of this identical Bernie break-in, yes.
Well, anyway, you say in the motion for required finding, we'll see this claim raised.
Correct. And also he raised it as well. See, this issue keeps coming up throughout the whole trial because it comes up not only in the motion for required finding, but it also comes up in the jury instructions, which the instruction that the judge gave was just not quite accurate. He said, look, if you find that he received these goods, you could still find him guilty of the B&E with intent to commit a larceny, which is really not reflective of what the case law is. And the waiver argument, just so that the Court is aware of it, is the Commonwealth versus Carlino at 449 Mass 71. It was just decided in May 2007 in a footnote, which basically argues that, look, there are a couple of cases in there that you don't waive it even if you don't raise it in the court below. So there's a little ambiguity with regard to that waiver issue. So with regard to that. And my remaining arguments are that the jury instruction was improper. It was not reflective of what the case law really is with regard to this.
But let me get back to the waiver issue. Why isn't
Certainly.
it waived? The right to double jeopardy is the right not to be tried twice.
Correct.
If you don't raise the motion to dismiss before the second trial, and the second trial proceeds, why haven't you waived the issue?
Well, and you know what, and you're in agreement with about half of the cases, and there are other cases that say, no, it's not waived.
So tell me why.
I think the argument that one of the cases raised was it's more akin to a subject matter jurisdictional issue, where they were likening it to that and saying, look, this is such an important issue, it's like subject matter jurisdiction where you can raise it at any point. I know that there's two cases in that footnote that say that it's not deemed waived. But I agree with you, Judge, the safe course of action should have been a motion to dismiss with these issues. But my feeling is that that there's a case law that can support the proposition that it's not deemed waived. And with regard to that, I would also argue that the jury instructions were also not quite correct. And I also, and aside basically with these inconsistent verdicts, there's this separate issue that dealt with the collateral estoppel issue when he brought his motion to suppress. And the trial judge said, you had your day in court and collateral estoppel applies. Unfortunately, at the time that appellate case came down, it did not have the benefit of this court's decision in Ringcat.
But if you choose to plead guilty and not exercise your right to appeal, why isn't that a final judgment with respect to the motion to suppress that was decided in the proceedings?
Well, I think the issue that this court again raised in the Ringcat decision was item 5, and it talks about whether something's deemed a final judgment.
But in Ringget, the case hadn't gone to judgment, and you can't have collateral effect without a final judgment.
Correct.
So isn't that a distinction between this case and Ringget?
Well, I would argue that you need to look to the incentive of that, whatever the proponent is, in terms of what are your incentives to appeal that decision. In everyday reality, when defendants lose their motions to suppress, they routinely, will wait until after whatever judgment is and then raise that issue, whatever it is, on direct appeal.
But they lose that right to appeal it if they plead.
Well, they don't, yes. I mean, if you plead guilty, what would be, in essence, you have no appellate review, in essence, because you pled guilty, why do you care whether there was error in your motion to suppress? Who's going to do that?
Well, you're not going to do that, but that's a final judgment. That's one of the things that you have to take into consideration. The case law isn't that you can't be collaterally, that there's no collateral estoppel until you've had appellate review of every issue, which is what you seem to be arguing.
Well,
you collaterally estopped is when there was no way to go further on the issue. It can't be that there's no collateral estoppel for a ruling that hasn't been appealed. You can have a trial in a civil case and then nobody takes an appeal.
correct. And that's when it comes up, is when people settle. In essence, what's happened here is that the party settled. He decided, look, I don't want to take my chances at trial for whatever reasons, or even in divorce cases. In the civil arena, that occurs when people, settle. Then you don't have that incentive for appellate review for error, in terms of that.
Okay.
So,
Thank you, Ms. Quintilian. Ms. Benedetto?
May it please the Court, my name is Annette Benedetto, and I represent the Commonwealth in this case.
Can I ask you the question that seems to be bothering us? Because I think that it's very important whether there is some distinguishing feature here between the two fact situations. Do you have anything that can educate us as to whether, in the receiving stolen property charge, whether he was charged with receiving different items than he was charged with in the B&E?
I believe he was charged with the 37 pagers and the cell phones that were found in the car.
And on what
I
do you
think the
base
record
that?
supports that, Your Honor.
All of
Where?
which came from Bernie's?
It came from Bernie's. As the facts are explained in the court, the police picked up these items, took them back to their police station, powered up the cell phones, and it said by Bernie's.
Yeah.
At that point, they did not have evidence of who was involved in the burglary. It was just this fellow and these four.
Well, we now know that we've got, and you say we have, 37 pagers that are Bernie's that were stolen by this man and others on the night of the break-in. So why isn't this double jeopardy?
Because he was never charged with larceny. He was charged with breaking. He pleaded to the receiving. 4 years later, he was charged with breaking and entering.
Well, what's the difference?
With intent to commit
With
larceny.
the intent to commit a larceny, but he was never charged with the larceny. His colleagues were charged with the larceny, but
if you're charged with receiving stolen property, you cannot be charged with larceny.
And that's why he was not charged with larceny, Your Honor. He was charged with breaking and entering.
But it's just
receiving stolen goods. Breaking and entering is a different charge from
Now, if
larceny.
you had charged him with breaking and entering with intent to commit malicious destruction, that'd be a different story, because they tore the roof apart a little bit to get in there, and a few other things.
But I guess it's the Commonwealth's position that the key part of that crime is the intent to commit the larceny. The intent was proven by some of the same goods, in 2004 as he pleaded to in 1998.
Into my house today and steals the television, and tomorrow he's caught with the television in his truck. He can be charged with B&E and receiving?
Well, that's a good question. I guess he could be, because he's not being charged with the theft itself.
Let me go
He's
through.
only being charged with the two separate crimes.
Let me go through the components with you, though. You agree that you cannot be charged with breaking and entering with the intent to commit larceny and larceny. Do you agree with that?
I do agree with that, Your Honor.
And do you also agree that you cannot be charged with larceny and receiving the same property that was allegedly stolen?
That's correct, Your Honor.
But you're saying that you cannot be charged with, you can be charged with breaking and entering with the intent to steal, and skipping over to the third component, receiving stolen property.
That's what happened
Okay.
in this case.
So-
Even though it was 5 years apart, it's what
Now,
happened.
are you agreeing that this was the same property?
Yes.
Yes.
What I'm agreeing with is that these pagers that he was charged with having possession of in 1998 was the property that was in Bernie's, which was only submitted as evidence of his intent to commit the larceny and not on the larceny itself. I mean,
As far as the $80,000 worth of merchandise that was taken,
I think they ever found that, Your Honor. The only thing they had were these pagers, and, I mean, that's my recollection.
So the breaking and entering in the nighttime with intent to commit the larceny, the evidence of that larceny was the same evidence as the evidence that was relevant to the receiving stolen property?
A little part of it, yes, that's true.
Well, no. Oh, it's either yes or no.
Yes, it was, there was the same evidence, that's correct.
So there's no evidence of any further items being taken in regard to the B&E nighttime with intent, or whatever, it's B&E with intent to commit a larceny. No further evidence of any more goods than what was used earlier for the plea.
I
Do you have a-
believe
Is that
that's so,
right?
Your Honor. That is right,
Okay, well,
Your
that's
Honor.
key to your case. I think that destroys your case.
Yeah, what's your strongest case that supports you on your theory that this isn't double jeopardy? Yeah, you have cases cited, but they all clearly are distinguishable.
Well, we have,
You have St. Pierre and a few others, and, manslaughter case, so forth.
we have a
This
case.
is just kind of screwy facts is what you got here.
Well,
but-
we have, it developed the way it developed in the facts, which
Oh,
is they had no idea who was involved with this burglary until one of the participants,
Yes,
some
but in the
years later.
second trial, they could have put in evidence, maybe, of more things being stolen. Have this guy who testified, right? Didn't he testify, the one who turned? The witness?
Yes.
Okay, so he could have testified that, this defendant, Cabrera, organized this ring and that they stole many, many things beyond the pages.
Well, what was put in testimony, and it was only to prove the intent to commit, as I keep saying, was the testimony of the manager who did talk about the particular burglary and put in pages.
Yes,
and
but you could have gotten it
No,
from
I'm
the
very,
other
but I'm very
guy.
confused here. I don't know whether we're talking by each other. I have an exhibit here called Exhibit 47, Proof of Loss, which reports the burglary and lists $67,000 worth of merchandise stolen. Was that put into evidence
That
at the
was-
trial?
I believe it was, Your Honor.
Yeah, that's what that exhibit. So there is evidence of all of this property having been stolen in that break.
That's correct. Your
And I thought the co-defendant, or excuse me, the co-conspirator who testified for the Commonwealth did testify about all kinds of DVDs and other kinds of electronics that were stolen,
That's correct, Your
in
Honor.
addition to these pagers, which is what was found 4 years
Right.
previously. All right, so there really was evidence at that trial of a lot of additional stuff stolen.
That's correct, Your Honor, but as I said, it was put in not to prove just the intent part of the crime. That's
Well,
correct, Your
evidence
Honor.
is evidence, I mean.
Well, that's true, but not to prove a particular element, because once we get to, very deliberately did not charge the larceny as the other people were charged because of the prior receiving stolen goods.
What do you say about waiver of double jeopardy? Is it a subject that can ever be waived?
I believe that the case that I cited says this is the way to waive it, and, this is the way to assert this particular privilege. And that, but I think that this court, it's a little confusing, and I guess...
Structural error?
a miscarriage of justice.
No, structural error. Isn't it a structural error? You can't, there are very few structural errors, but I thought that was
Right,
one
I
of them.
understand.
Isn't that one of them? I don't know. But I'm somewhere at the back of my mind, I seem to remember that this is a structural error, that the state cannot punish you twice for the same. And so it is akin to subject matter jurisdiction in that sense.
Well, I think the proper way, of course, is to to move to dismiss.
Of course, that's,
But I
everybody
don't,
concedes that that's the, but
right.
that's more judicial administration.
Right.
Don't waste the court's time, and everybody else's time.
Right.
Well, there's two tests for double jeopardy. One is, I think, the common elements test, which isn't met here because the B&E's got the breaking and entering part of it. The other is the factual constellation. If the factual constellation leads to the two crimes, do we still follow that test?
I think the Arriaga case does distinguish between the same conduct and the same element, and I think in a successive prosecution,
But at one point, we were following a test. I can't remember which one it was now. I think it was the Common Core Facts test, and then we sort of disavowed it, I think, didn't we?
Well, my reading of these cases are that in this particular instance, it's the same conduct, but I put in same elements
Okay,
as well,
same
to say
conduct.
that it proved, they could win on both things. I wanted to call the court's attention to the Williams case, which was not in my brief.
Have you given a copy to counsel?
I haven't, I just found it yesterday.
What's the site?
It's 397 Mass 298, 1986 case, in which this court said consecutive sentences for the offenses of breaking and entering in the nighttime with intent to commit a felony, larceny in a building, and malicious destruction of property over the value of 100. It says conviction for each of the offenses required the Commonwealth to prove an additional fact not required for conviction of the other offenses, and the court essentially affirmed that particular ruling. So I will give this to my co-counsel. Opposite.
Benedetto, would you comment on the collateral estoppel issue?
Well, the Ringette case had not been decided.
I understand. I
Right.
understand.
So it's really just the factor number 5, which is the critical factor here. And of course, we assert that it was a final determination. It was a plea.
Isn't that akin to a settlement? So it's pre-trial. It's not an appellate thing. It's pre-trial. It's a settlement. It's not a final adjudication in that sense.
I think a judgment of conviction by plea is as final as it can get. And it's
Judgment
also
is final. It's whether the issue has been finally adjudicated.
well, the Ringette factors
The four.
are met on all these grounds.
But we tossed out 5, didn't we?
You tossed out 5, excuse me, that's right. And the SJC, this court in the last Ringette case ruled that because there was no right of appeal by the defendant, but that's very different from this particular case, because in this particular case there was a plea and there was a conviction and a final judgment. Plus, this rule, the first proceeding resulted in a final judgment on the merits. In Ringette, the defendant had no right of review of the decision on the motion to suppress. It was only a discretionary review. But in this particular case, it's different. And this court also, in another case that I've just recently been called to my attention, the Williams case, 431 Mass 71, has bound the Commonwealth under the same facts to an issue that had already been litigated. So this parallel situation is a finality rule. So in both situations, the judgment was final. So if there are no further questions, I'd like to just rely on my brief. Thank you.
Thank you, Ms. Benedetto.